So this revocable trust is drafted, obviously, while you are alive. And if it is done right, which it often isn't, it is actually funded while you are alive. So let me tell you what is a huge mistake that so many estate attorneys make, is they draft these revocable trusts. And by the way, one of the purposes of drafting a revocable trust, as opposed to just leaving money in your will to somebody, is to avoid probate. But if you want to avoid probate, you not only have to draft the revocable trust, you actually have to fund the revocable trust. So I can't tell you how many people come into our estate planning office, and they have these revocable trusts, and I say, great, where's your money? And they'll say, oh, it's in my name, or it's in joint name with me and my spouse. So they have these trusts that don't control any money. So at death, the trust is not avoiding probate. And typically you will have a will. We call it a pour-over will. And the purpose of the pour-over will is in the event that you missed an asset in terms of funding the trust. And the will says whatever money is not controlled by the revocable trust that is a probate asset, and we'll talk about probate assets in a minute, whatever money is not controlled by the revocable trust, because it wasn't transferred to the revocable trust, will be transferred to the revocable trust. But if you have a will that says anything that wasn't in the revocable trust goes to the revocable trust, how does it get to the revocable trust? It goes through probate. So there's no point in setting up a revocable or living trust unless you actually fund it, because the whole point is to avoid probate. We'll talk about probate in a minute, but I will just tell you that it's a very common mistake, and I guarantee you that a reasonable percentage of the people in this audience listening today, some attorney drafted a revocable trust and no assets were transferred to the trust, which is just a mistake. Now, it's not a catastrophe, because assuming that the will was drafted correctly and the will is, and the estate attorney did do what's called a pour-over will, it will say any assets that weren't transferred to the trust that should have been transferred to the trust are transferred to the trust. Now, to me, the purpose of that is, let's just say for discussion's sake, you have $1 million of probate assets and you appropriately do transfer those assets to the revocable trust, but maybe for whatever reason there was an account that wasn't transferred, or maybe for some reason there was some asset that would typically be controlled by a will or a revocable trust that wasn't transferred to the revocable trust. Well, in that case, you might have to go through probate for that one particular asset, but at least the vast majority of your assets would avoid probate. That is the purpose. And I keep going over this again and again because it is such an important, it happens so often, and it's really silly, and it costs time and money. And if the point is to avoid probate, and for a lot of people that makes a lot of sense, then you should do it right, or don't even bother with a revocable trust at all, just plan to go through probate. If you do this, though, you set up the revocable trust, you can be the trustee, your spouse can be the trustee. If you can have a joint revocable trust, that is, you can combine your monies and put both of your monies into this revocable trust. You can have a his, hers, and theirs, and sometimes that is appropriate. Obviously, it's a little bit more paperwork, but that might be appropriate. And you can be your own trustee. Your spouse can be the trustee. If you're joint, you can both be trustees. There might be situations where you might want an adult child to be a trustee. And the trust will typically say the settlors, or the people who are establishing this trust, they can do whatever they want during their lifetime. They can spend it, they can blow it. If If it's a house, they can live in it. They can rent it out. They can paint it green. Whatever they want to do, they can do. But it also has provisions on what happens at death, either after the first death or even after the second death. So people draft these trusts to avoid probate for probate assets. And again, you have to transfer these assets to the trust. And this revocable trust will control the distribution of the probate assets. What are probate assets? They are typically assets that are not controlled by beneficiary designation. So what are assets that are controlled by beneficiary designation? Well, for example, your IRA beneficiary will supersede anything that you put in your will or your trust. So if in your will or your trust you say, I leave my IRA to Bill, and if you look to the beneficiary designation of your IRA and it says, I leave it to Joe, then Joe wins and he is the beneficiary of the IRA, and that supersedes what the will says and it supersedes what the revocable trust says. And obviously this should be working together. That is, the same estate attorney should be very cognizant about who the beneficiary is of the IRAs and retirement plans, who the beneficiary is of everything else, and plan accordingly. Our firm, one of the things we love to do is we call it a strategy called who gets what. And we will very often have different assets go to different beneficiaries. To the most common one that attorneys routinely botch. Here's you want a quick way to save $24,000, assuming you're charitable, or even a little bit charitable. All right, so what do most estate attorneys do? Let's say you want to leave $100,000 to XYZ charity after you and your spouse are gone. All right, so they put it in the will or the revocable trust. After I and my spouse are gone, I leave $100,000 to the XYZ charity. Okay, so you and your spouse die, $100,000 goes to the XYZ charity. All right, now that just cost your family $100,000 because if you had just left it to your family, they'd have received $100,000. Instead, you left it to the XYZ charity, so that's $100,000 that your family didn't have. Well, what if you change who gets what? So you say, I leave $100,000. And by the way, mechanically, the way you do this is through the beneficiary designation of your IRA and or retirement plan. I leave $100,000 of my IRA to the XYZ charity. All right, now let's take a look at the implications of that. So now the XYZ charity gets $100,000 at your death. The XYZ charity could care less the form of the money that they're getting. They don't care if it's an IRA, after-tax dollars, Roth IRA dollars, etc. What they care about is who got the most money or how much money are they getting. All right, so in that example, your family is getting $100,000 less of an IRA. But remember, an IRA is still taxable after you're gone. So that $100,000 that they aren't receiving didn't really cost them $100,000. Let's just, to simplify, let's just use a 24% tax rate. That really just cost them $76,000. So by changing who gets what, we are saving $24,000 for your family. So who's in effect eating that $24,000 savings that your family is receiving? Well, it's the IRS. All right. So we might sometimes want different beneficiaries for different assets, and it has to be strategic. By the way, another example of who gets what is perhaps you have two children that are financially very unequal. One is maybe a spendthrift, needs a spendthrift trust, will always be in a low tax bracket, et cetera, et cetera. The other one is doing really well. But you still want to treat them equally. Well, maybe leave the Roth IRA and the after-tax dollars that are tax favored to the child who is doing well and leave the IRA to the child who is in the lower income tax bracket. And if that child is a spendthrift or for another reason needs a trust, you can leave that money in the IRA to that child in the lower tax bracket. So I guess my only point is the estate attorney should be considering the entire estate when they are determining who gets what, the appropriate estate plan, and what money is controlled by either the will or the revocable trust, which are probate assets, and what assets are outside probate, like a IRA or retirement plan, or, by the way, a jointly held property. If you own jointly held property, typically a house, the house that you live in, for most of you, if you have not transferred it to a joint revocable trust, I would imagine that the title of your house is in both your and your spouse's name as joint tenants in common. And what that means is at the first death, literally the millisecond of death, the ownership of that jointly held asset will then go to the surviving joint owner, which, by the way, is another way of getting around probate, because it doesn't matter what the will says, the jointly owned property will supersede any trust or will. So this revocable trust does control the distribution of probate assets at your death, and some people call it a will substitute, if you will. All right. So what the heck is probate? Well, probate is a court-supervised process, and it's very important to know that. So if your plan is to go through probate, you should know that the court of whatever county you happen to die in, they are going to become involved in your estate. One of the things that does is, and one of the responsibilities of the executor who is helping administer the estate is to prove the authenticity of the will. Yes, this is accurately represents the last wishes of the person who died, showing that person had capacity, which sometimes comes up in the event that, the day before he died, he left everything, instead of to his wife and his kids, he left everything to the attending nurse. Well, maybe he didn't have capacity to do that. Maybe there was undue influence, et cetera, et cetera. But anyway, proving that the will is authentic and is the last wishes of the person who died, identifying what assets are controlled by the will, and then officially appointing somebody who handle the affairs of the deceased, typically called the executor, or the female is executrix. One of the responsibilities is to protect the estate until the estate is distributed. So if it's, for example, a house, make sure that the house doesn't fall into disrepair, make sure that the lawn is mowed, make sure the plumbing still works, make sure the house isn't ransacked, etc. It is to pay the debts of the estate and to pay any taxes that the estate might incur. It is to identify the heirs that are listed and distribute the assets to the heirs according to the wishes displayed in the will. All right, so why do people want to avoid probate? Well, first, a lot of people just want to avoid the time and expense of having to deal with the court. That's probably a good reason right there. Anything that goes through probate, anytime you have to get a court involved, you're always talking about additional time. The court itself makes a charge, so you're saving some money from court. The other thing that's a biggie is that the probate process does become a matter of public record. And this is important. Now, when when I was a young lawyer, if you wanted to look up somebody who died will, you had to go into this dusty room. I did it myself for purposes, um, and this dusty room, and it had this very complicated index called the Russlander Index, and really only like law students and clerks and attorneys knew how to use it. But you could basically look up what somebody put in their will, anybody who died in that particular county and whose assets went through probate. Well, now a lot of that is online. And then again, it's a matter of public record. So if you want, you can just check out what somebody has in their will, uh, of course, after they died. But you might not want that, in which case you might prefer having a revocable trust control your assets as opposed to a will. There are many executors that will charge a percentage of the probate estate as their fee. And by the way, I'll tell you a quick story. When I was working for, I don't even want to mention the firm at this point, but I was working for, well, it's okay. I was working for Arthur Andersen. I won't mention the client, but the client was a big bank. And the big bank handled a lot of trusts and estates, and the big bank had problems. They understaffed the people that were preparing tax returns for their trusts and estates, and they needed people to come in and do the tax returns. And that's not a typical tax return. So you can't get a CPA off the street and say, I want you to do these tax returns for these trusts and estates, because they're kind of specialized returns. And I was one of those guys who had that specialty, and I was working for Arthur Andersen. And anyway, this big bank hired the Arthur Andersen team to go in and prepare trusts and tax returns for trusts and estates. So I was able to see, and to his credit, our partner said to this client, well, we will do that, but we're going to do Arthur Andersen quality, which means we're going to read the trust, we're going to read the wills, we're going to do the allocations the way that they're supposed to, and we're really going to do this right. Anyway, I saw the inside of what happened to money after people died, and I just saw huge fees going to banks and to attorneys as executors and attorneys of estates, typically based on a percentage of the estate. I won't say that the work was done particularly well, and I would just say that if the work was done on a fair hourly basis, that the fee might have been tens or even hundreds of thousands of dollars lower than they actually were when you had this big bank and you had this attorney who both, by the way, charged a percentage of the estate. And I had two reactions when I saw these enormous attorney fees based on a percentage of the estate. My first is, that's outrageous. That's unfair. The client's getting ripped off. This should be done on an hourly basis. And then I thought, wonder if I can get in on that. But I did not, let's say, choose to go to the dark side. We always do estate administration on an hourly as opposed to a percentage basis. But by the way, that often doesn't happen.